In this video, we will answer the question, how do you go about dropping charges if you are the victim in a domestic violence case? The answer to that question is coming right up. Welcome to Gustitislaw. I am Steve Gustitis, and this is my channel. If you're new to Gustitislaw, I post weekly videos just like this one on how to effectively navigate the criminal justice system, how to manage encounters that you may have with the police, and how to defend criminal charges. If you enjoy the content here, consider subscribing by hitting the red subscribe button down below or that black and white G down in the lower right-hand part of the screen. I also enjoy questions and comments on these videos, so add those down below in the comment section, and I will answer those as quickly as possible so we can begin a discussion that may help other people as well. This is video number 3 in our series on domestic violence defense strategies. Links to other videos in the series can be found down in the description section. In this particular video today, we will discuss how the victim in a domestic violence case can go about dropping charges with their prosecutor. The first important takeaway from this video is this. If you are the person accused of domestic violence, do not put any pressure upon the victim to drop the charges. In fact, if you are the accused, you probably should not be talking to the victim at all about dropping the charges. Let your criminal defense lawyer talk with the victim and make this request of them. In this way, you are insulated from any type of allegation that you might be trying to manipulate the victim or manipulate this situation. Criminal defense lawyers who are experienced in defending domestic violence charges know how to handle this very delicate situation. So let them do the talking for you. If you are the victim in a domestic violence case and you want to drop the charges, I suggest that you contact the prosecutor's office yourself and find out what their process is and what their procedures are for making this a non-prosecution request. Most prosecutors, if not all, want to talk with the victim before accepting these non-prosecution requests to make sure that the victim is not being threatened or coerced into signing these papers. So, in order to make sure that your request for non-prosecution is given the greatest consideration possible, make sure that you're following their rules and doing it their way. And remember this, that the prosecutor is not obligated to drop the charges simply because you ask them to. They may have office policies in place, and there may be facts specific to your case that have great impact on the prosecutor's ultimate decision on whether or not to end the prosecution or not. But in any case, you want to make sure that you're doing it their way to make sure that your request is given the greatest consideration that it can be. Do you have any questions about how to go about dropping charges if you are the victim in a domestic violence case? If you have questions, consider sharing those down in the comment section, and I will be happy to answer those for you to try to help you clear up any misconceptions or questions that you have about this process. The next video in this series on domestic violence defense strategies will cover what are called BATTERER intervention programs, otherwise known as BIPs. We will talk about how the BIP program can be used to help defend your domestic violence charges. So stay tuned to Gustitislaw. I appreciate you being here and being part of the Gustitislaw community. And don't forget to give the video a thumbs up if you liked it, and don't forget to subscribe.